Good afternoon, everyone. My name is Andrew Demers. I'm the Communications Director here at the New Hampshire Insurance Department and welcoming you to our 2025 Legislative Session Wrap-Up webinar. As always, we are very happy to entertain questions, so if you have any during the presentation, please enter them into the chat box and our subject matter experts will address them at the end if they don't address them during the presentation. I'm happy now to introduce our Deputy Commissioner, Keith Nyan.
Thank you very much, Andrew. I appreciate it, and I want to kind of start off today by welcoming everybody to our call, and on behalf of the Insurance Department and Commissioner, to say, thank you. Unfortunately, the Commissioner is unable to join us today. He's attending our GNC meeting over in the Seacoast area. So today you'll be listening to myself present on kind of the key accomplishments on the legislative side related to our property and casualty and finance divisions. And then following me, I'm going to introduce our Assistant Commissioner, Jason Dexter, who is going to cover the life and health bills that were passed. Kind of as we kick this off, I want to say, there's a special thanks to everybody involved in this process. And while we certainly don't want to, we don't want to overlook anybody, we had numerous people here from staff involved in these bills. We worked with our industry partners, mostly, licensees, and we certainly don't want to overlook the bill sponsors and elected officials, which are kind of, really core to the success that we had over the last year. And on that note, just kind of a quick overview. We did wrap up another very successful legislative season where the department advanced more than 80% of its initiatives. So today we're going to hit on some highlights of those and break it out by property and casualty and life and health. So to that point, I'm going to kick it off by sliding over here on the property and casualty side. And one of the more prominent bills that we were able to advance and see successfully passed was our Continuing Care Retirement Communities Bill, or Senate Bill 124. For those on the call who aren't aware, CCRCs, Continuing Care Retirement Communities, are communities that provide care for various stages of living, in many cases, for the remainder of a senior citizen's life. Notably, the department, however, while we do not regulate the quality of care provided in those facilities, which is done so by our sister agency over at Health and Human Services, the department regulates the solvency of those facilities, as well as some of the basic contracting that takes place between the facilities and those residents. The CCRC bill sought and does modernize the oversight of these entities, where again, seniors often have invested their life savings for housing and care. Typically, when a senior enters a CCRC, there's a very large entrance fee that's paid, and there are monthly fees for ongoing care. So, consistent with the department's regulatory approach when we're developing bills, it was a very collaborative effort in working with the industry to come up and address some deficiencies. And those deficiencies were really made, the department became aware of relative to some CCRCs that one had filed for bankruptcy and another had found itself in some financial difficulties, made its way to our radar. And frankly, when these bankruptcies occur, it jeopardizes the residents' refunds and abilities to remain in those facilities. Really, if the facilities close or otherwise be turned into apartments, our seniors not only lose their entrance fees, but in many cases wind up losing their homes. So to address these issues, we rewrote our existing statute, and it provided for some very critical improvements in that law. One of them, it's really kind of an advanced warning system now for the department that those CCRCs are now required to file quarterly reports with the department. And these are reports relative to financial solvency and liquidity. But again, working with our industry partners, we were cognizant of the fact that not all of these facilities need to have that increased scrutiny. So it's a stepped approach to our regulation, in that if a continuing care retirement community has more than 80% occupancy and 100 days of cash on hand to pay pay bills and they're not in default of their loan covenants, they're subject to less oversight. Still have to file those quarterly reports, but again, not quite as stringent. The law also includes a new Bill of Rights, which, as it certainly suggests, lists out the rights of those residents. And it really recognizes that members are seniors and need to be appropriately treated. One of the other rights, it includes a requirement that a member of the community, a senior, be a representative on the board of directors. Lastly, as we move forward, we brought forward from our prior legislation, prior law, a requirement that there be a certificate of authority, contract and disclosure requirements to the members, and that a resident, when he or she does enter a facility, has a right to rescind that contract within 15 days after execution. So really, the bill really sought to modernize our regulation, providing more consumer protections. And it's at its core, it's about peace of mind for seniors and their families. Moving forward, another critical part of the legislative success this past year was the technical corrections bill put forward by the department, which is House Bill 499. The bill modernizes our insurance code, effectively cuts some unnecessary fees, and really kind of streamlines our oversight. The critical pieces of that, and I'm going to break it out into about 5 sections. Section 1 cleans up language from last year's Senate Bill 173, No Surprises Act, to really align existing insurance department language and laws with the federal program. We have an individual dispute resolution process, which now mirrors the federal law. So we had to clean up some language. And this is a provision whereby providers and consumers can come to the department when they believe a bill has been improperly assessed against them as it relates to health insurance. Section 2 of the technical bill is a notice requirement from our property and casualty lines licensees that when those companies are discontinuing certain lines of business, that they notify the department. Not currently a requirement in law, now it is. And it just gives us a heads up so that we here at the department can be prepared to handle questions coming in from both licensees as well as members of the public. Sections 5 through 8 of the technical bill cleans up language to basically just, dotting the I's, crossing the T's, such that current statutory language aligns with current business practices. We also had an amendment, fairly significant amendment in my eyes, which requires for licensees, new companies coming into the department, that they have a paid up capital moving from $800,000 to $3 million. This ensures that only serious companies, serious players who want to enter our insurance industry are able to do so. So that we move that capital requirement from $800,000 to $3 million. Another important part of our technical bill was really, we took a hard look at some of the fees that the insurance department was assessing, in particular for licensees who are making, address changes, really ministerial type changes that we used to have a manual component to processing. As those of you who have looked at fees before, fees are designed to cover the cost of the administration to implement those changes. We took a hard look at it, and a lot of those manual procedures that we used to have to undertake, we no longer do. The modernization and allowing consumers or licensees to make those changes directly online allowed us to eliminate those fees. And those are fees, ranging, I think it was anywhere from $25 to $200. So we eliminated, name change fees, things, name change following marriage. We eliminated mail return fees, address change fees, and several others, again, where our licensees are making those changes on their own. And then lastly, we did have a section, second to last, we cleaned up some reporting requirements around network adequacy. And this relates again to the adequacy of health networks providing care for insureds. And then We also cleaned up Senate Bill 515 passed last year. This is on consumer guarantee contracts. There was a ministerial error in our law that we just needed to clean up to align with the intent of law. Overall, I would probably summarize the technical bill as an effort to eliminate red tape. So we have less red tape. It was really resulted in direct cost savings for our licensees, which has an indirect and positive effect on premiums for our consumers, and really kind of modernized the way we're doing business. Basically aligns current practices with the law. And then lastly, I wanted to touch on an issue that we've been monitoring. This is also going to be an upcoming legislation, which is the third-party litigation funding transparency. And this is House Bill 733. It was retained. This proposal actually increases accountability when there's outside financiers funding lawsuits in the state. The department strongly supported the bill last year, and we will remain involved working with legislators to see it move forward this year. Why is it important? This particular legislation requires disclosures of litigation funding agreements, prohibits foreign entities of concern from funding litigation cases, and allows full discovery of these agreements. And it really becomes important to the extent that litigation is a huge factor in premiums. If you think about some of the, cases that are, more prominent in the media, we have child care providers who, the cost of insurance is excessive. And they struggle many times to obtain affordable liability coverage. These hidden funding agreements increase risks and costs. It would be a significant improvement for our marketplace by making these agreements transparent such that our insurance entities can properly rate for those risks, which should help bring some of these costs down. So right now we have carriers that are funding for the unknown. Once we have a transparency requirement, licensees can more accurately predict what some of those costs may be. So on that note, that kind of does a quick recap of the major bills that were passed on the property casualty and financial regulation side. And on this note, I'm going to transfer it over to our Assistant Commissioner, Jason Dexter, who's going to walk you through a couple of very important bills. Thank you.
Thank you, Keith. Appreciate that. Great job. Thanks, everybody, for coming. Again, Jason Dexter, happy to walk through a couple of health-related bills that impacts that world this year. There's some bills that we're going to talk about that were initiatives that the department brought forward. There's some bills that we were ultimately asked to pitch in a little bit. So I'll be talking about 6 in total. We're going to start with the big one, which was Senate Bill 245, which was ground ambulance form. And what the legislature did this last summer was enact one of the strongest consumer protections in our state's history, which is a ban on surprise billing for ground ambulance services that goes into effect January 1st. For many decades, families were blindsided by ambulance bills during a moment of crisis. They really didn't have much recourse. This law ends that scenario. So key highlights from the bill include there's no more balance billing. So if you have an ambulance bill, you're going to pay what you would typically pay in your in-network cost. It also creates a more fair and predictable reimbursement for ambulance providers, which it's calculated at 325% of Medicare for the next 2 years, and then will develop into a permanent cost-based schedule. In addition, it strengthens our ambulance network by trying to develop standard contracts that can cut red tape and make it easier to get those contracts in place. And ambulance providers are also committed to audits to access those enhanced rates. Really is a bipartisan solution that reflects Governor Ayotte's directive of protecting consumers, supporting EMS providers, and controlling the cost of premiums. The department was central in shaping a framework that achieves all three. There's a lot of work for a lot of people at the department. at carriers and ambulance providers. It's a long time coming. So we're happy to have this bill pass. So the next bill I'm
Jason,
going to go ahead, Keith.
I was just going to jump in and say, this was a bill that I just wanted to pick up on something that you said, which was you had a lot of people here involved from the department. And kind of the real victory here for the department was, that as you mentioned, that consumer protection and the prohibition on balance billing. So, again, having been involved in our consumer division for a number of years, we have dealt and continue to deal with many, many complaints on this matter. And I can't stress enough how important that is for consumers. So thanks for allowing me just to jump in and say that.
Absolutely. It's a big deal. Yeah. We'll be glad not to have those complaints coming in as often as they used to. Okay. Next bill is what we'd bucket as Medicare Advantage protections. It was Senate Bill 121. And the department was seeing scenarios where we were receiving consumer calls about individuals who were losing their Medicare Advantage products. And we took the initiative to get a law that ensures the department gets 90 days notice before carriers exit or make major changes to their Medicare Advantage plans. And in the past, seniors would get these notices and they really wouldn't have as much time as we'd like them to have. So now we'll be ready and we can get our resources and guidance available and ready for them when they call. Ultimately, it creates some transparency and accountability and helps these families better transition if their Medicare Advantage plan is gone. They have more time to think about what the next step is. It's practical common sense reform driven by both legislative leadership and the department's goal to protect New Hampshire seniors. So we are seeing, even though this bill is, I think it's effective a little bit in the future or just recently effective, we have seen carriers voluntarily comply and give us information, which has been nice to see. Next is House Bill 507, which relates to mental health credentialing. This is just an important bill that brought mental health providers on par with primary care physicians. So when they have credentialing applications filed, that there's a 30-day deadline that it's now clear also applies to mental health professionals. And this will help get more carriers or more providers in the market sooner. It's such an important thing, and get patients and families faster access to care. It again reiterates the importance that Governor Ayotte puts on mental health services and is in New Hampshire Insurance Department's leadership in advancing practical patient-centered change here. Next is a bill that started off as Senate Bill 246 and ended up language that was incorporated in the state budget trailer bill, commonly referred to as House Bill 2. This is the New Hampshire Momnibus 2.0, which expands maternal and infant health protections. Some of the highlights here are coverage for maternal depression screening under Medicaid and private insurance, funding for perinatal psychiatric consult line, rural EMS maternal health services, and a study on birth center sustainability. And it expands coverage for perinatal mental health, substance abuse, and home visiting. Includes up to 25 hours of workplace leave for postpartum and pediatric appointments. And ultimately, Momnibus 2 ensures earlier screenings, stronger supports, and healthier beginnings for families. It's a bipartisan achievement led by the legislature and government and Governor Ayotte, with the department playing a key role in shaping coverage reforms that delivered real results. Another bill that there are a lot of people involved with. Took some time to get this done, but happy to see this passed to provide better coverage for consumers. So that's the bills that passed that we wanted to talk about today. There's a few that we're going to touch on briefly that relate to retained legislation. These were, first bill was House Bill 705, which relates to healthcare cost transparency. And this bill would require insurers to publicly post real prices for care, including what they pay providers, out-of-network costs, and prescription drug prices. It standardizes the data, which enables NHAD to build a cost comparison tool and ensure timely updates that's available to consumers. Goal here is to help families make informed choices. Ultimately, the legislature wanted more time to refine some of the details. We're looking forward to working with them, but that bill's out there is retained right now. Lastly was House Bill 297, which is a bill that really is targeted towards self-funded employers, and it gives, there's a scenario where self-funded employers can opt in to having their claims data submitted to the New Hampshire CHIS. This bill makes clear if they do that their data will be available to them out of the New Hampshire CHIS. It ultimately will enable businesses to have better insight into their healthcare costs and ultimately make more informed benefit design decisions moving forward. Another bill that the legislature wanted a little more time in this. We'll continue to work with them in the future. So those are the 6 bills that I had to cover today. I will pause for a moment, see if we have any questions out there for either the health or property and casualty world for Keith and I to look at.
All right, well,
Jason, this is Keith. I was going to say, I think if the commissioner was here, he'd say something along the lines of, I know I didn't do that good a job. There's got to be questions.
Well, we do have questions.
I see one from Lori Carey in the chat, and Michelle has answered that about reimbursements from ambulances. And so hopefully, Lori, that Michelle answered your question. If you have any other questions, we invite participants to type them into the chat window now. And if you have a question that you'd like to ask us offline, you can always connect with us at communications@ins.nh.gov. That goes to our communications unit, and we will make sure that the right subject matter expert gets your question, and we can provide a timely answer for you. So I guess last call for questions, and then we'll offer Deputy Nyan any closing remarks. Not seeing any questions. Keith, go ahead. Oh, I see one here. Tony says, like the 90-day notice for Med Advantage folks. I don't know if it's a question or not.
I'm going to take that as a compliment. Yeah, this is great stuff. Jason had mentioned that, this law goes into effect January of 26. In advance of that, we have already had our Medicare supplement carriers that are Medicare Advantage carriers that are making changes in the upcoming plan year. They've already brought themselves into compliance in advance of that law taking effect. It has been very, very helpful to the department to kind of understand the landscape of what is going to occur in advance and to try to prepare for it accordingly. And, as those of you who are in that space knew there were changes last year, there were some plans that were discontinued. We're certainly seeing more of that in the upcoming year. So, it's very helpful, and we are preparing internally properly so that we can better assist both the consumers and our licensees navigate that. So,
I see one more question from Melinda. She asks, are you aware of any Advantage plans exiting the state?
So I'm sorry, I'll answer that. The short answer is, the department has been made aware of carrier plans. We're not allowed to discuss those plans until they're public. The change is constant, and we are preparing. So I apologize for not being able to give you a direct answer, but yes, we have been notified, and there are changes coming. Related to that, though, I will say, Andrew, that I did have a discussion with a couple of Medicare Advantage producers last week, and I have been made aware that our licensees, the Medicare Advantage carriers, have been proactively communicating their plans with those licensed producers. So while we at the department cannot disclose that information, carriers are taking it upon themselves to disclose to their appointed agents.
Okay, thank you. Well, not seeing any other questions. Keith, any final comments from you?
I would just say, thank you very much to everybody involved. It's been the legislative season is always very interesting here at the department. It's almost borders on chaos, a lot of cooperation, a lot of discussions, and we're very pleased with the advances that we made last year. We're looking forward to another robust year this cycle, and encourage all of our industry partners to continue to collaborate with us. We honestly believe that as we bring new efforts forward, when we can have those collaborative discussions before rules are filed, it makes not only for better legislation, but for a more expedient legislative process. So thank you very much to everybody involved. We look forward to talking with many of you and working with many of you in the upcoming months. So thank you.
All right. Thanks everyone for joining us today. Hope you have a great day. Thank you.